What is the legal status of the high seas for naval activities? Imagine vast stretches of ocean that are not owned by any nation, yet they are vital for global security and commerce. These expansive areas, known as the high seas, cover nearly two-thirds of the Earth's surface beyond national jurisdiction. Understanding how these waters are governed, especially concerning military operations, is essential for grasping international maritime law. The legal framework governing the high seas is primarily established by the United Nations Convention on the Law of the Sea, often abbreviated as UNCLOS. This treaty, which came into force in the year 1994, provides comprehensive rules for the use and protection of marine environments, navigation rights, and the conduct of activities including military operations. While UNCLOS does not explicitly prohibit or restrict naval activities in the high seas, it sets out principles that influence how nations can operate there. Naval activities on the high seas are generally considered lawful under international law, provided they adhere to certain conditions. For example, ships, including military vessels, enjoy the right of innocent passage through the territorial waters of other nations, but this right does not extend into the exclusive economic zones or the continental shelves beyond. When operating in the high seas, naval vessels are expected to respect the rights of other states, avoid interference with lawful uses, and comply with applicable international regulations. Furthermore, the principle of freedom of navigation is a cornerstone of high seas law. This principle allows ships of all nations to sail, fly, and conduct military exercises without interference, as long as they follow international rules. However, this freedom is not absolute. It must be exercised responsibly to prevent conflicts and protect marine resources. Certain activities, such as piracy, illegal trafficking, and unauthorized broadcasting, are explicitly prohibited on the high seas. Naval forces play a crucial role in enforcing these prohibitions, often collaborating across nations to ensure security and stability. Additionally, ships engaged in military activities are subject to international laws concerning conduct, safety, and environmental protection, even when operating in international waters. In summary, the high seas are considered international territory governed by a set of legal principles designed to promote freedom, safety, and cooperation among nations. Naval activities are permitted under these laws, provided they respect the rights of other states, follow international regulations, and contribute to maintaining peace and security on the global stage.